him trying an explosive device to himself at the point of arrest. He said during his time in Southeast, he did not arrest any native doctor making sham for kidnappers. Also, that the checkpoints of police and the army are still functional in the Southeast today. PW5, Mr. EEE is an officer of the Department of State Service in the National Headquarters, Abuja. According to him, in July 2021, he was instructed to lead a team of officers of the police and the DSS, photographers and other investigators to travel around country to obtain and collect record of activities that occurred between 2020 and 2021 relating to the NSAS movement. He stated that the assignments included obtaining records from head of security agencies in the states visited, particularly the states in the Southeast and the FCT, obtaining reports of deaths and death certificates of security personnel who died, as well as public properties destroyed as a result of NSAS protests and riots. PW5, while referring to Exhibit PWD2A, stated that 8 policemen were killed in Abia, 19 in Anambra, 13 in Ebonyi, 16 in Enugu, 16 in Imo, 17 in Akwa Ibom, 16 in Cross River. There were 6 police officers killed in Lagos, 9 in Rivers, bringing a total of 128 policemen killed. With respect to military officers, a total of 37 killed. The DSS had 10 casualties. A total of 167 police stations were destroyed during the protest. Then 9 INEC facilities were damaged and destroyed. Under cross-examination, PW5 stated that he only investigated the death of security operatives who were killed during the NSAS protest following the incitement by the defendants who instigated protesters to kill security agents and even taught them how to manufacture Molotov cocktails to use in the process. He further said it is on record that the defendants urged protesters to destroy public buildings in places like Lagos. He said he does not know if one of the protesters, Aisha Yusuf, is sympathetic to Biafra or is a member of IPOB. He said he is aware that the police brutality was one of the causes of the NSAS protest and that the defendants urged people to take up arms against the government. PW5 said there is no part of the report stating the activities of IPOB or ESN. He also said all protocols relating to taking of photographs were duly observed. He said from pages 669 of the report, there are some visible dates on the photograph. PW1 stated that there is no portion of the document signed by himself as secretary of the Presidential Ad Hoc Committee of the committee that investigated the aftermath of the NSAS protest and the chairman of the committee. However, he stated that he certified the document and that the document was not certified after the proceedings of 12th day of June 2025. The defendants had filed a notice of preliminary objection dated and filed 16th October 2025, seeking for the following reliefs. 1. A declaration that they continue the prosecution of defendants under the Repealed Terrorism Prevention Amendment Act 2013 upon a prescription under order obtained ex parte and without fair hearing violates Section 1, Sub 2, Section 36, 1 to 12, and 42 of the Constitution of the Federal Republic of Nigeria and Article 7 and 28 of the African Charter and is therefore null and void. 2. That a declaration that the Federal High Court ex parte order prescribing IPOB obtained without notice or hearing and while Justice Peter Inyako's substitution ruling that IPOB is not an unlawful society remains in force, is unconstitutional, unlawful, and cannot ground criminality. 3. An order striking out or permanently staying counts 1 to 8 saved counts 15 of the amended charge dated 14th January 2022 for being barred by double jeopardy, having the same factual ingredients as count 6 to 14, earlier struck out by the Federal High Court on the 8th day of April 2022. 4. An order declaring that the defendant's extraordinary rendition from Kenya without extradition proceedings on due process violates Section 36(1) and 9 of the Constitution, the Extradition Act, Cap E25, Law of the Federation of Nigeria 2004, and Article 12 and 13 of the African Charter, thereby robbing the court of its jurisdiction. 5. An order nullifying all proceedings conducted in breach of the defendant's right to adequate facilities for defense, confidential communications with counsel, and for fair hearing, particularly dropping, seizure of legal materials, and denial of unmonitored access. The notice of preliminary objection has 43 paragraph affidavit deposed to by Ms. Nnamdi Kanu, a seedling to the defendant. The affidavit has 10 exhibits and a written address. In his written address, the defendant submitted inter alia that the Court of Appeal in CA/ABJ/C/625/2022 had ruled in his favor on the 13th day of October 2022, holding that his extraordinary rendition has divested the trial court from continuing his trial. Thus, the instant trial is unlawful and in disobedience of the order of the appellate court. The defendant relied on the case of Okafor versus AG Anambra State, citation supplied, to submit that any charge promised on repealed law cannot sustain and sustain any proceedings, that the provision under which his charge has been repealed by Terrorism Prevention Act 2022, and thus he has no life to sustain these proceedings. He also submitted that his extraordinary rendition, as well as not affording him adequate facility, denies him of his fair hearing, and thus he urged the court to quash the instant proceedings against him. He also argued that the court is divested of jurisdiction as the subject matter of this charge is sub judice before the Supreme Court. He thus urged the court to uphold the preliminary objection. In written address filed on 30th day of October 2025, the defendants substantially repeated the submission in the notice of preliminary objection regarding the repeat law, extraordinary renditions, and denial of fair hearing. He therefore urged the court to quash the charge against him. The court formulates the following issue for determination. After going through the evidence, the address of the defendants deemed to be final written address and that of the prosecution, the court formulates this issue. 1. Whether the defendant was denied his right to fair hearing in these circumstances of this case. 2. Whether the claim of extraordinary rendition of the defendants from Kenya invalidates his trial in this case. 3. Whether the provisions under which the defendant is being tried are repealed law and inoperative. 4. Whether the prosecution have established the charge against the defendant beyond reasonable doubts. Defendant has challenged the jurisdiction of this court as well as the competence and validity of the trial before this court. He premised his objection on the legality of the extraordinary rendition from Kenya in 2021, upon which he was brought back to Nigeria to face trial. He also raised an objection to the denial of his right to fair hearing, and that the charge was premised on repealed law, and thus the charge ought to be struck out against him.
This court will painstakingly consider this jurisdictional issue before going to the substantive issue if need be. Jurisdiction is a general term referred to the extent of power and authority exercised by a court over a particular matter. It is seen as a threshold issue which determines how a court should handle a matter where jurisdiction is lacking. Any other action taken by the court amounts to nullity. Kindly see the position of my noble Lord Abiru, JSC in NIMR versus Akin, Olubade and others, citation supplied. Equally see the enunciation by my Lord Ada, JSC in Abu versus Sule and others, citation also supplied in this regard. On issue 1, with respect to the alleged denial of right to fair hearing of the defendant, the tenet of fair hearing is to the effect that both sides in a dispute must be heard as expressed in the Latin maxim or the Otaram pattern, that a party can not be a judge or the Otaram pattern, and that a party cannot be a judge in its own cause, as expressed in Mazin, Nemo Judes in Kasaswa. Fair hearing is enshrined in Section 36(1) of the Constitution of the Federal Republic of Nigeria, and it provides in the determination of its civil rights and obligations, including any questions or determination by or against any government or authority, a person shall be entitled to a fair hearing within a reasonable time by a court or
other tribunal established by law and constituted in such manner as to secure its independence and impartiality, unquote. Also see the case of MFA versus Inoga, citation supplied, where it was heard, and I quote, fair hearing within the meaning of Section 36 of the Constitution of the Federal Republic of Nigeria 1999 means a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. It requires the observance of 2 pillars of the rules of natural justice, namely, or the Otaram pattern and Nemo Judes in Kasaswa. Simply means that no judge should decide over a matter in which he has personal interest or involvement, unquote. Also, my noble Lord, late Nikki Toby, GSC of blessed memory in INEC and Musa, citation supplied, heard and enunciated on the principle of fair hearing. The defendant claimed that he was denied his right to fair hearing by the court, foreclosing him in the entry of his defense. As the risk of repeating myself, I will repeat my ruling of 7th November 2025, wherein I recounted the history of this case and proceeded to foreclose the defendant. This matter was filed in 2015, and due to the delay as a result of appeals and other issues, same was assigned to this court in March 2025. Prior to this, in 2017, the defendant was alleged to have jumped bail and escaped from Nigeria, and for about 4 years, the defendant was not in Nigeria within the territory of Nigeria, which caused a stall to his trial due to his absence. In 2021, he was brought back to Nigeria to face his trial. However, the defendant became unruly and caused serious delay in the trial before my learned brother, Nyako J. The issue got to a head that the defendant began asking my learned brother to recuse herself from the trial on the basis of being biased towards him. The judge recused herself, and the matter was assigned to this court in March 2025 for trial. Upon assumption of jurisdiction, having in mind that this matter has stayed for 10 years and the interest of justice, I granted a selected hearing. As a result of the accelerated hearing, I created morning and afternoon session in this court so as to accommodate this trial. The prosecution opened its case. In total, the prosecution called 5 witnesses and tendered several exhibits. The court ensured that the prosecution was kept on its toe
during the presentation of this case, and same was closed on the 19th day of June 2025. It is worthy to observe that during the time when the prosecution was calling its witnesses, several adjournments were at the instance of the defendant. For instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant's counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant counsel applied for adjournment. In addition, on the 14th day of May 2025, defendant applied for an adjournment. Also, on the 21st day of May 2025, defendant applied for an adjournment as part of the options opened, as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court overruled same, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing, as contained in Section 36 of the Constitution, that the defendant shall be given opportunity to defend the charge he is facing. Upon this, the defendant was called upon to do so. The court in that ruling also pointed out the need for evidence to be given on oath, to give evidence on oath to challenge the evidence of the prosecution. In that no case submission ruling, the court mentioned the importance of the defendant to give evidence on oath because this is a criminal matter. It is not civil, where the standard of proof is on balance of probability. It is a criminal matter which the standard required under Section 135 of the Evidence Act 2011 is beyond reasonable doubt. It's worthy to note that extraordinary rendition is a quasi-criminal issue in a criminal case, and evidence on oath must be given, and the opposing side must be given opportunity to cross-examine on that quasi-criminal issue in accordance with Section 135 of the Evidence Act 2011. Also see the case of Edevie versus Orobobe citation supply, where the Supreme Court held that where any allegation of crime or quasi-criminal are made in any matter, even in a civil matter, affidavit evidence will be insufficient and only oral evidence will be entertained due to the standard of proof being standard required in criminal matter, which is beyond reasonable doubt. These defendants had the duty to prove the allegation of extraordinary rendition in this criminal matter beyond reasonable doubt. The defendant has not called anybody to testify on oath in respect of extraordinary rendition, which would enable the other side to cross-examine such witness. The failure of the defendant to give evidence on oath on extraordinary rendition has made the allegation bare. It is simple and assertion without proof. The court was constrained to deliver the no case submission ruling earlier, as during the vacation of this court, the defendant has filed an application that he be moved to a private ward in the National Hospital, Abuja, as the facility of the Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the president of Nigerian Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether he is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical reports raised at that stage was empty of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays the trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the president of the Nigerian Medical Association and determined that the defendant is indeed fit to stand his trial after no opposition from the defendant and the prosecution as regards the reports. The court had carefully observed the defendant during the entire trial and the spirited nature of the defendant. His unruly attitude and his agility in defending himself shows without that he is indeed fit to stand trial. Thus, corroborating the conclusion reached in the report by the panel set up by the president of the Medical Association, even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium or other nutrients as stated in his supporting affidavit to his application for transfer to National Hospital are not such that render him incapacitated from understanding the proceeding in this trial. He is healthy, fit, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold, without doubt, that the defendant is fit to stand this trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu Agabi, had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense. Despite the fact that there was no evidence before the court of the DSS dropping on the conversation of the defendant and his counsel, the court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting, since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025, just to accommodate the defendant and his counsel. The court then adjourned the hearing for 23rd, 4, 24, 27, 28, and 29 and 30th October 2025 for the defendant to open
and close his defense. On the 23rd of October 2025, the learned Sikh representing defendants including Kanu Agabi SN, Onyechi Peazu SAN, Polokoro SAN announced to the court that they wished to withdraw their appearances as the defendant has indicated that he wanted to defend himself. The defendant confirmed the development and informed the court that he wished to represent himself at the trial. Upon exercising his right to defend himself, the defendant came on the next date, and his excuse was that he was not given his case file by his departing counsel. This was no doubt another cause of a delay on his part. The following day, the defendant appeared for himself and began challenging the decision of the court, arguing that there was no charge against him and that the medical report certified him fit was alleged doctor. The court patiently explained to him that some of these issues he is raising have been treated in no case submission, and some of other issues could be raised during the final address. The court then advised him to engage counsel who are experts in criminal litigation due to the seriousness of the charge against him. The court also offered to secure the service of counsel from the legal aids or a private legal practitioner willing to take the matter pro bono, which were all rejected by the defendant. The court continued to appeal to him and even went as far as begging him, in the name of God, to please engage counsel and open his defense, all of which fell on the deaf ear. At a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of whom he claimed are foreigners as witnesses in his case. He applied for witness summons. The court graciously immediately approved the witness summons. However, the defendant abandoned these said witnesses and began claiming that he had gone through the case file and he found that there was no law providing for the offenses he is being charged with, that he could not defend a charge not found on a law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put in his defense. The court, in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself, herself, is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant expressly or by conduct waives same. See Segun Ogunsoya and the state citation supplied. The defendant refused to open his defense, despite the court informing him that it was minded to extend the day if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that defendant come on the next day to put in his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th October 2025, the defendant filed a motion on notice / comprehensive written address on notice on address on non-existence of a cognizable charge and the unconstitutionality of continuing of trial filed 30th of October 2025, and same will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The import of treating the written address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for reliefs, including 4. The court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt, the defendant clearly knew what he was doing by opting for final written address in form of motion / comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This would therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgments. Also, the preliminary objection filed on 16th October 2025 is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to be, when the charge was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Court, take it again. Count 1. Registrar, after it, do you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 that I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agabi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provide thus: 1. The defendant to be tried on a charge or an information shall be A. brought before the court unfettered unless the court sees cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service, and where the court finds that he has not been duly served. 3. The court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case it is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999, as amended, provide every person, I quote, every person charged with criminal offense shall be entitled to be given adequate time and facility for the preparation of his defense. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the state, citation supplied. As part of the package of rights available to a person facing criminal charge, he is entitled to all the facilities and enough to time for purpose of preparing his defense. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat JSC in Okoye and COP, citation supplied, where my Lord said, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense. The court must accede to his request and the prosecution has to comply. The facilities that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statement of the witnesses interviewed by the police in the course of their investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward for to testify, unquote. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following date, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel, who he had earlier disengaged, to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denying adequate facilities to prepare for his defense. He had enough time to prepare. He had been represented by senior advocates such as Kanu Agabi SAN, Onyeshi Impeazu SAN, Emeka Ikpabas SAN, Paul Urukoro SAN, How do not get SAN, among others, before they were suddenly disengaged. And the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no water in the light of the facts and circumstances in this case. Consequently, this issue is resolved against the defendants.
And other places.
On the issue of extraordinary renditions, there are instances where a person commits offense against a country while residing in another country or flees the country soon after committing the same crime. In such instances, the country against which the offense is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a legal process in which a state renders a person accused of committing a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Enubuwa citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal fugitive flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have been tried and convicted but escape custody by fleeing the country and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable persons from a country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refers to its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the persons named in the warrant. Treaties signed in recent decades tend to take a dual criminalities approach, classifying an extraditable offenses that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses, unquote. Usually, the requesting and surrendering nation have a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes, such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender fugitives to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offense is committed. These extraordinary measures may include adoption. The Supreme Court of Nigeria alluded to this in the case of Federal Republic of Nigeria versus Nnamdi Kanu in SC/CR/13C12022, where my noble Lord Agim JSC held, and I quote, "Generally, abduction or kidnapped or any form of illegal removal of an accused from the territory of a state to another to face criminal trial or for a reason is prohibited by law. Extraordinary rendition or any other transfer without due process is unlawful. There is no doubt that the illegality in the process of bringing the respondent to Nigeria for the criminal case brought by the appellant against him in Nigeria, the attendant massive violation of his rights, render his prosecution by the appellant unfair and oppressive. While extraordinary rendition measures may, unquote, while extraordinary rendition measure may seem illegal on the face of it, the way and manner in which the attendance of a defendant is secured does not dictate his trial. In the United States of America, this is known as Kelfibri doctrines. This doctrine developed through the case law, notable cases of Kel versus Illinois, 119 U.S. 436 1886, and the case of Freebly versus Collins, 342 U.S. 519 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority. Addressing Kel's due process challenge, the Supreme Court of the United States held that, and I quote, such forceful abduction is not sufficient reason why the party should not answer when brought within jurisdiction of the court, which has the right to try him for such an offense and presents no valid objection to his trial in such case. In Freebreeze v. Collins, 342 U.S. 519 1952, it was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authority from Chicago, Illinois. Applying its decision in care, the Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kel Freebie doctrine is that even though the act of rendition is illegal, a trial court may assert jurisdiction over the person regardless of the legality of the adoption under international law. In recent times, the Supreme Court relied on Kel Freebie doctrines in United States versus Alvarez Machines in 504 U.S. 65 1992. Alvarez Michel, a Mexican citizen, was adopted and brought to the United States at the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States officials, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quasi-criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria is right that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of FCT versus Violence Consultancies Services Limited and another, citation supply, where the Court of Appeal held, and I quote, every forgery involves an alteration of documents, but not every alteration of documents amount to forgery. Forgery involves alteration with a fraudulent intent. The fact and incident of forgery must be specifically pleaded and proved even in civil matters, as in this case beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove safe. In a case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubt. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only swore to an affidavit. So the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily rendited or he was illegally brought to Nigeria. The gaps in evidence will therefore mean that no evidence was led regarding the extraordinary rendition. Assuming, without conceding, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus vitiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu, in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offense allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hold to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold." Unquote. When this issue came up before the Supreme Court, the Apex Court, in Federal Republic of Nigeria versus Kanu, in SC/CR/1361/2022, delivered on the 15th day of December 2023, the Apex Court held per ML Gaba JSA, and I quote, I quote my noble Lord M.L. Gaba JSC. I agree with the learned senior counsel for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offences in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences, and after jumping the bail granted to him by the trial court, cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in questions. In the above premises, the lower court, which is with the respect due to it, took its eye off the balls when it filed off the statutory jurisdiction vested or conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from the foreign country. The provision of Extradition Act Cap E25, Laws Federation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of foreign courts on them referred to and solely relied on by the lower courts to hold that the procedure used or employed to produce the respondents before the trial court to continue its trial had robbed that court of jurisdiction to adjudicate over or try the offences in question, did not create, define or punish the said offences, neither did any of them conferred or vest the statutory judicial power and authority or jurisdiction to try adjudicate over the offences in respondent, was charged with and validly arraigned for. Rather, they all merely provide or prescribe for the general procedure to be adopted in respect of their respective subject matter that do not include and have nothing to do with creating, defining, or punishing offences, and vesting or confining judicial power and authority or jurisdiction on courts to advocate over or try such offences. Once again, these laws and rules, conventions, etc., do not take away, deprive, or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce him before the trial court for continuation of his trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away, deprive, or even fetter the jurisdiction or conferred or vested on the court of record by the constitution or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In this result, the issue is resolved in favor of the appellant to the effect that the trial court is statutorily vested or conferred with the requisite jurisdiction to adjudicate over and try the offences in the retained counts of the charge the respondent was validly arraigned for, and that the procedure used and employed to bring or produce in for the continuation of his trial did not rob or deprive that court of jurisdiction. It was an error in law for the lower court to resort to and hold that the procedural law or entirely different subject matter of arrest, extradition, or rendition of runaway fugitive offenders accused person from foreign country deprived or robbed the trial court of the statutory jurisdiction. My Lord arguing in the same case also adds, and I quote, the established case law through the cases is that even though a strict alliance to statutory prescriptions concerning pre-trial criminal processes, the processes for bringing the accused to court for trial is a sine qua non for fair trial. Violation of the fundamental rights of an accused person or other unlawful action by the prosecution at the pre-trial stage gives the accused person the right to action for remedy for violation of his fundamental rights and other civil remedy, and has no effect on the validity of the whole criminal proceedings against him and the jurisdiction of the court to entertain the proceedings and try him, provided the facts alleged against him disclose an offence created by written law and a reasonable basis for suspecting he committed the offense. So the established case law in Nigeria is that violation of fundamental rights of an accused person and any illegality in pre-trial or extraordinary process in relation to an accused person should not affect jurisdiction of the court to try ensuring criminal cases and the validity of such case. That is the basis for the admission of relevant evidence obtained from illegal searches and seizures or searches that violates the accused person's fundamental right to privacy. In Nigeria, there is hardly any case where the jurisdiction of a court to try a case is declared to be ousted by or validity of the case declared vitiated by the unlawful arrest and detention of an accused person at the pre-trial stage of that case or by any unlawful extrajudicial action of the prosecution after arraignment during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite restatement of the House of Laws in Al versus Osprey relied on by Court of Appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of law, promotion of rights for territorial sovereignty of states, enforcement of international law, adhering to due process of criminal law to ensure that prosecution does not benefit from abuse of its power and abuse of court process. But the reality in Nigeria's peculiar situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful action of the prosecution that occur in the process of investigating the criminal complaint against him or in the process of initiating the criminal case against case arising from such complaints or in process of bringing him to court or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and brazen violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that notwithstanding the legality or otherwise of how the defendant was brought back from Kenya, it does not invalidate his trial. The court will curtail the line set by the Supreme Court as the apex court of the land. His decisions are final, overrides all other courts, including the Court of Appeal, which defendants has erroneously relied on heavily. Kindly see Section 235 of the Constitution of the Federal Republic of Nigeria 1999 and the case of Adama Tanker Brokering Services Limited against CBN citation supply. The fact in this case is more distinguishable. Even than in Kelfibri case in U.S. with respect to the effect on the jurisdiction of court to try the defendant as held by the Supreme Court per Gamba JSC. In that case, the defendant was already arraigned before this court, and in this case, the defendant was already arraigned before this court, and the jurisdiction of this court had been activated as far back as 2015. More so, he had been compensated monetarily in suits he filed in Kenya, unlike in Kel Freebury case, where the defendants were not on trial before their rendition. Despite the fact that in Kel Freebury they were not arraigned before the extraordinary rendition, their trial were not invalidated in U.S. The defendant in this case, on being granted bail, was alleged to have joined bail by leaving Nigeria, and for 4 years. The trial was granted until he was rearrested in 2021 in Kenya. This action of the defendant makes him a fugitive. In this case, the trial has begun, and the charge has been filed and read to the defendant before the alleged extraordinary rendition. He cannot then claim that the trial is vitiated by the extraordinary rendition. The alleged rendition of 2021 will not deactivate the jurisdiction of the court activated since 2015. I hold without hesitation that this is an exception to the effect of extraordinary rendition in international law. Even if the extraordinary rendition was wrongful, the remedy for it is at best monetary damages in civil proceedings. The court is aware that a court in Kenya had ruled on this issue and awarded monetary damages to the defendant. The court in Kenya had awarded monetary damages against the Kenya government for gross violation of defendant's rights, fundamental rights. The defendant cannot benefit from monetary damages awarded to him and seek a further relief of his trial being vitiated, particularly seeing the nature of the offences, which borders on terrorism. This is similar to the enforcement of fundamental rights to personal liberty in Nigeria. A successful application for unlawful arrest entitles the applicant to compensation or an apology, but it does not extend to vitiating a criminal trial where the charge has been preferred against him. Consequently, this issue is resolved against the defendant. On issue 3, defendant has challenged this court, arguing that it is based on repeat law. The general rules regarding a charge is that it must be premised on written law. See section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, and it provides, and I quote, subject as otherwise provided by this Constitution, a person shall not be convicted of any criminal offense unless that offense is defined, and the penalty, therefore, is prescribed in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of states, any subsidiary legislations, instrument under the provision of the law, unquote. The above means that a person to be tried and convicted, the offense must be in existence and provided for under law, a law in force at the time. See the position of the Court of Appeal in Daniel versus Federal Republic of Nigeria, citations of light. The law is also settled that the trial and conviction of any person upon a repeat law is a nullity. This was the position of the Court of Appeal in IGP versus Ogundimu, citation also supplied. A law, once repealed, ceases to have any life and must be treated as dead. And the Supreme Court in State versus Egigia initiated on this, and I quote, the law is settled that a repeat law no more has legal life. Thus, it cannot be cited as if it still exists. If it must be cited at all, it must be cited as a repeat law, which has no life to influence an argument. A repeat law cannot be the basis for any comparison with existing law. It cannot be quoted side by side with the existing law, as learned advocates did. Now, the defendant argued that the Terrorism Prevention Act 2013 had been repealed by the Terrorism Prevention Act of 2022. Thus, the trial has become spent. The argument by the defendant is quite interesting. It is interesting because it shows the stark misunderstanding of the law by the defendant, as well as his willful disregard of the facts accumulating in his trial. Firstly, the defendant is charged under the Terrorism Prevention Amendment Act 2013. The extant charge is as to offences allegedly committed by the defendant between 2018 and 2021. As at when the extant charge was filed, the Operational Terrorism Act in Nigeria was the Terrorism Prevention Amendment Act 2013. That act was duly passed by the National Assembly and signed into law by the President, Goodluck Jonathan. It empowered the court to try terrorism-related offences and also outline what constitutes acts of terrorism under Section 30 of the 2013 amendments. The Act provides thus, and I quote, "The Federal High Court located in any part of Nigeria, regardless of where the offence is committed, shall have jurisdiction to try offences under this Act." Unquote. Section 1(2) of the same law defines terrorism as follows, and I quote, "Any act deliberately done with malice, aforethought, which may seriously harm or damage a country or an international organization, is intended to intimidate a population, compel a government to act or abstain from acting, destabilize a fundamental political, constitutional, economic, or social structure of a country," unquote. The above provisions were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. His initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment Act 2013 was the extant law of the land. It would have been different if the defendant's offences were allegedly committed after the Terrorism Prevention Act 2022 have been enacted. The Terrorism Prevention Amendment Act 2022 comes into effect on 12th day of May 2022, which is a later date compared to when the alleged offences were committed. The Supreme Court in Federal Republic of Nigeria versus Kanu Supra, the present defendant in this case also ruled on that issue and held, and I quote, "Now, even a casual look at the offences stated in count 1, 2, 3, 4, 5, and 8 of the charge pleaded to by the respondent before the trial court readily shows that they are offences provided for in 2011 Act as amended and by the 2013 Act under which the charge was filed and brought, and the respondent was properly and validly arraigned before the trial court. Put another way, the offences the respondent was arraigned for before the trial court are offences known to and specifically provided for under and by the provision of 2011 Act as amended by 2013 Act. The offences are therefore recognized, cognizable in law, to be legally grounded and backed by the provision of extant and existing law that was /is in force at the material time and now. On its part, count 15 of the charge is indicated to be contrary to section 47(2)(a) of the Criminal Code Act, cap C45, Laws of the Judgement of Nigeria 2004. There can be no reasonable dispute that the Criminal Code is an extant and existing statute or act that was or is in force in Nigeria, which the court has the duty to take judicial notice in this appeal, pursuant to provision of section 122 of the Evidence Act 2011. In addition, the court is also entitled to take judicial notice of the codification and publication of all the acts or statutes, the subsidiary legislations, enactments or passed by the National Assembly as contained in the laws of the Federation of Nigeria, published by or under the authority of the Federal Ministry of Justice of Nigeria at various times, because we here are concerned with the laws of Federation of Nigeria 2004, in which the Criminal Code Act is indicated to be. I have noted and pursued the laws, perused the law, and Acts codified and published in the Laws of Federation 2004 as published. The Criminal Code Act is published in Volume 4, comprising of Chapter C24 to Chapter C48. It is in Chapter C38, which is subsequently indicated as Cap 38. The Criminal Code Act is in Chapter 38 of the Laws of Federation of Nigeria 2004, and it's also called or shown to be Chapter C38 in Volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not Cap 45 or Cap C45 in Volume 4 of the Laws of Federation of Nigeria as indicated in Count 15 of the charge against the respondent. Rather, Criminal Code Act is Chapter 38 or Chapter C38 in the Laws of Federation of Nigeria 2004. However, the same Laws of Federation of Nigeria 2004, Chapter 45 or Cap C45 is the Custom and Excise Management Act. A calm reading of the details of the facts stated as constituting the offense mentioned or named therein will clearly and undoubtedly reveal that it deals with offense punishable under the provision of Section 47(2)(ba) of the Custom and Excise Management Act C45, Laws of Federation of Nigeria 2004, which provide as follows. 47(2) if any person A imports or causes to import any goods or conceal in a container holding goods of different description, he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C45 and C45 in Laws of Federation 2004 is a mere mistake in place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offense in Cap 15, is punished or punishable. The offense in Count 15 is consequently recognizable, and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on-book law that a charge preferred or filed for offense under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offense on the charge are known to defined and punishable punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative in both two counts, that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as Cap C45 and Cap C45, Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial court are punishable and punished. The offences once more are recognized, cognizable, and ground instant and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98. 1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificate, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given or done under the Repeal Act shall, if enforced at the commencement of this act, continue to be enforced and have effect as if made, issued, given, or done under the corresponding provision of this act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or course of actions pending or existing immediately before the commencement of this act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The import of this provision, particularly section 98.3, is it serves as a saving provisions which ensures that the amendment of the act does not affect the validity of trial begun under the Repeal Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or other of course are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the Repeal Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against the defendant. With respect to the substantive issue, I must start the resolution by outlining the effects of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, in criminal trial, the defendant has the three options available to him. Upon the closure of the prosecution case, he has the option of making a no-case submission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far has been so discredited under cross-examination that it would be unsafe for the court to convict him. Another option open to a defendant is to put in his defense where he will be opportune to state his side of the story as well as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case chooses to make no case submission, and this court overruled his no case submission on the 26th day of September 2025 and ordered him to put in his defense. It is his constitutional right to do so. He, however, refused to do so. He rather consented to the withdrawal of his learned senior counsel representing him, despite the courts employing him to enter his defense on several occasions, even begging him, in the name of God, as a minister in the temple of justice, passionate about justice, as an apostle of Jesus Christ, I begged the defendant passionately and severally, but the defendant was obstinate and refused, and the court had no choice than to foreclose him. The effect of this is that the defendant has chosen to rest his case on that of the prosecution. The defendant this morning confirmed this fact by saying that he has put in his defense. effect of the defendant resting his case on the prosecution is that it is a gamble, a risky option, which may boomerang if the evidence adduced by the prosecution is believed by this court. The Supreme Court in Adamu and States, citations supplied, held, and I quote, "The law is generally settled that an accused person who, at the close of prosecution case, decided to rest his case on that of the prosecution as presented against him is only exposing himself to risk and gamble. The reason being that if the case is such that even if all the prosecution witnesses are believed, yet the offense as charged is still not proved, then the accused may get away with the risk of resting his case on that of the prosecution. By that choice, the accused will have decided not to explain any fact in rebuttal of the allegation made against him." See also the position of the Supreme Court
in the case of Ajibade and State citation supply, where the court held, and I quote, "Appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view," unquote. See also the case of Hakim Idisseyin versus Olajide, citation supplied. The defendant in this case deliberately refused and failed to call any witness and present evidence through his witnesses in rebuttal of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count 1 of the charge, the defendant is facing a charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast received and heard in Nigeria with intent to intimidate the population and threaten that people will die and the whole world will stand still, thereby committing an offense punishable under Section 1(2)(b) of the Terrorism Prevention Amendment Act 2013. The same section provides a person or body corporate who knowingly in or outside Nigeria, directly or indirectly, willfully commits an act preparatory to or in furtherance of an act of terrorism, commits an offense under this act and is liable on the conviction to maximum of death sentence. The ingredients of the offense as drawn from the above are: 1. The defendant must be a person or body corporate. 2. The defendant must have done an act preparatory to or in furtherance of an act of terrorism. 3. The defendant must have done the act preparatory to or in furtherance of terrorism act knowingly or willfully, and same may be directly or indirectly. See the case of Ada versus Federal Republic of Nigeria, citation supplied. Looking at the first ingredients, there is no doubt that the defendant in this case is a person. He is known as Nnamdi Kanu. A man is in 50 who stood trial before this court. Thus, the first ingredient is resolved in favor of the prosecution. For the second ingredient, the prosecution led evidence showing that the action of the defendant in making broadcasts threatening that people will die constitutes a terrorist act. Terrorism or a terrorist act, according to online Oxford Dictionary, is, I quote, the unlawful use of violence, intimidation, especially against citizens in the pursuit of political aim, unquote. It is also important to explain what constitutes terrorist acts. Section 1(2) of the Terrorism Prevention Amendment Act 2013 provides us, and I quote,
in this section, act of terrorism means an act which is deliberately done with malice, aforethought, and which A, may seriously harm or damage a country or international organizations. B, is intended or can reasonably be regarded as having been intended to 1. Unduly compel a government or international organization to perform or abstain from performing any acts. 2. Seriously intimidate the populations. 3. Seriously destabilize or destroy the fundamental political, constitutional, economic, social structure of a country or international organizations. 4. Otherwise influence such government or international organization by intimidation or coercions. C. Involve or causes, as the case may be, 1. An attack upon a person's life which may cause serious bodily harm or death. 2. Kidnapping of a person. 3. Destruction to government or public facilities, transport system, and infrastructure facilities, including an information system, a fixed platform located on the continental shelves, a public place, private properties, likely to endanger human lives or result in major economic loss. 4. The seizure of an aircraft, ship, or any means of public or goods transport and diversion, or the use of such means of transportation for any of the purposes in paragraph B(4) of this subsection. 5. The manufacture, possessions, acquisition, transport, supply, or use of weapons, explosion, or of nuclear, biological, chemical weapons, as well as research into development of biological and chemical weapons. The Supreme Court, by my noble Lord Kekere Ekun, JSC, now the CJN, heard in Abdul Mumuni versus Federal Republic of Nigeria, and I quote, Section 15(2) of the EFCC Act provides, any person who commits or attempts to commit a terrorist act or participates in it, facilitates the commission or induce any government body or institution, the general public, or any section thereof, to do or abstain from doing any act or to adopt or abandon a particular standpoint, or to act according to certain principles, or to disrupt any public service, the delivery of any essential service to the public, or to create a public emergency or create general insurrections in a state. Any promotion, sponsorship of, contribution to, command, aim, incitement, encouragement, attempt, threats, conspiracy, organization or procurement of any person with the intent to commit any act referred to in paragraph A(1), 2, and 3, unquote. It was further added, and I quote, the crucial aspect of offense of terrorism is the creation of intense fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act, or to adopt or abandon a particular view, policy, or position to act according to certain principles, unquote. See also the case of Berende versus Federal Republic of Nigeria, citation supplied. In my research, I came across a handbook from the United States Institute of Peace titled Teaching Guide on International Terrorism. definition, causes and responsibilities, or properties to intimidate or coerce governments, the civilian populations, or any segment thereof in furtherance of political or social objective is derived from Federal Bureau of Investigations. What therefore, unquote, what therefore constitutes a terrorist act from all the definition above is an act of violence, threat of violence intended to cause fear, put the recipients of such violence TV contained in Exhibit PWW. The defendant was interviewed by one Rodolph Okonkwo. He was introduced as the founder and director of Radio Biafra. When the defendant appeared on the screen, his nameplate was Nnamdi Kanu, director Radio Biafra. While speaking on the national conference in Nigeria, which was organized at that time, the defendant mentioned the name of some of the representatives from the Southeast as the conference, and he said, if you go there and negotiate any other thing apart from Biafra, you better not come back because our people will be waiting for you, that very person, unquote. When he was asked about the consequence for this representative, including one Ike Nwanchuku, defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people don't understand. Lugard killed many people to put Nigeria together, and the killing of people to disintegrate the zoo shouldn't come to anybody as a surprise. Our promise is very simple. If they fail to give us Biafra, Somalia will look like to 1970. It's not 2010 to 2015. Then we had scientists, but now we have people who can make things happen even better than what we had in the late 60s. So that should ring a warning that we are not joking. 8 minutes mark in the flash. He said, I do not believe in peaceful actualization of whatever rubbish is called. I have never seen where you will become free by peaceful means, unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu Katrina Lungs and the British government to know that we have chosen the path of death and people are dying every day. We have to develop the mindset of after this, which even though NATO is there, NATO is there. We say that we are ready to die, and everyone that comes to kill us will die also, because things will start happening in the next 14 days. In the next 2 weeks, the slaughter will begin to happen. You see those CNN that have refused to come to Biafra. We come by force to see what is happening. We will make sure that every Nigerian soldier on Biafra soil will die. God is my witness. I will lead this burial myself, unquote. Around 55 minutes mark to the exhibit, he said, and I quote, I want the United Government to understand that we are ready to die and
The hotel referred here to is Oriental Hotel in Lagos, which the defendants alleged belonged to Tinubu. While responding, the number of police other security into the program, informing the defendant that he was at Oshodia Papa Expressway and that they are killing them. The defendant, annoyed by this information, stated how many police or army did you kill? I don't want to hear that. They are killing you. How many did you kill? Unquote. The caller then responded that they have burnt the Orile police stations and Ilasa police station. The defendant then told the caller not to wave the green, white, green flag of Nigeria, but a blood-stained flag with the color green, white, red. He further responded
to another caller by saying, what I want them to do is to set ablaze the United building along Marina on fire. Every federal government property in Lagos should be burnt. That is what is going to be signal to the world that people have had enough. I want every federal government building in Lagos to be on fire. Every federal government vehicle or anything belonging to federal government, burn it. Go to the Muritalem Wane airport, burn it. How many soldiers do they have? Manufacture your own weapons and ambush them. Unquote. The result of this incitement is the killing of several military officers, police officers, DSS officers. The incitement also led to the destruction of several police stations in Lagos across the southern states of Nigeria. According to PW5, he led a team of officers to investigate the destructions and killing of the security personnel that occurred during the NSAS protest of 20th October 2020, as contained in Exhibit PWD2 and Exhibit PWD2A. The results were quite alarming. The court is mindful not to attribute all the happening during the NSAS protests on the defendants. However, there is no doubt that the incitement by the defendants contributed largely to the killing of security operatives, as well as destruction of public properties. The defendants incited people to destroy property such as the Lhasa police station, other police stations, and properties of the government. The evidence before this court shows that the
Said properties were actually destroyed, such as the Lhasa police stations.
The High Court of Lagos in Igoshere, as well as BRT buses belonging to Lagos State government in Oyinbo. PW2 also testified that military corpus were killed by those incited by the defendants in Olu in Imo State. In addition, PW4 stated that his driver and one of his tactical officers were killed as a result of the incitement. The action of the defendants were clear, as it was aimed to cause anarchy by killing security operatives in Nigeria, which would in turn lead to breakdown of law and order. The defendant had an evil intention to wreak havoc on the people and government of Nigeria. Are all these actions consistent with agitation for self-determination? The answer to this is in negative. His violent outbursts, as well as his instigations of the public to attack and kill security officers in southern Nigeria without provocation, was downright barbaric and without any conscience whatsoever. The defendant did not feel any concern for the family of the officers who were slain. He turned himself to a tyrant who could take life anytime he pleased. Such persons cannot be allowed to remain in society of sane minds. His shocking instigations to kill other human beings was incomprehensible, and this court hereby condemned it. But I must say that the evidence extracted is minute compared to the avalanche of. I must say that evidence extracted in this judgment is minute and very small to the avalanche of evidence and broadcast before this court by the defendant. The defendant made extremely threatening statements, incited people to violence. The prosecution has successfully discharged its burden of proving counts 4 and 5 beyond reasonable doubt. Consequently, the defendant is hereby convicted of the said counts 4 and 5. Now, count 6. For count 6, the defendant is charged with the offense of making a broadcast received and heard in Nigeria within the jurisdiction of this court, in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which he directed members of the indigenous peoples of Biafra, a proscribed organization, to manufacture bombs, thereby committing an offense punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Section 1(2)(f) of the Terrorism Prevention Act 2013 provides: A2. A person or body corporate who knowingly in or outside Nigeria directly or indirectly, willingly, assists, facilitates, organizes, or directs the activities of person, organization engaged in any act of terrorism. The ingredients of the offense expected to be established are: 1. The defendant must be a person or body corporate. 2. The defendant must have assisted, facilitated, organized, or directed the activities of person or organization engaged in terrorist activities. 3. The defendant must have willingly assisted, facilitated, organized, or directed the activities of persons, organizations engaged in terrorist acts. The defendants herein have been established to be a human being. As to the second and third ingredient, the prosecution has led evidence to show that the defendant has directed members of the terrorist organization to build bombs, other explosives in order to attack security operatives. Indeed, in furtherance of its terrorist actions and following the incitement of persons to kill defendant security operative, the defendant also directed his members to build explosive devices, particularly motorford cocktail. At about 1 hour, 30 minutes, 36 seconds of the broadcast of 20th October 2020, as contained in Exhibit PWW, the defendant, while responding to a caller about NSAS protest, stated, and I quote, "Now, this night, I want graduates to go to work, graduates of chemical engineering, those who were born as engineers, manufacture any ordnance you can, because they are coming to kill you anyway, regardless of what you do. Go and manufacture any ordnance. I am calling on the youth in the middle belt, and I want any bridge that they can use to reinforce to be destroyed. They are going to come from the middle belt. This night, we have engineers everywhere, people who are intelligent. Go back now and give us your own version of motor cocktail. We must destroy them before they destroy us. Every youth tonight, anybody with a police uniform, anywhere, especially in Aba, in Lagos, once you have police uniform or any army uniform, that person is your enemy. Attack them, because if you don't, they will kill you. If you are a graduate of physics or chemistry, no sleep for you tonight. Go and manufacture something to destroy the police and every army police position starting from this night." Unquote. During the said broadcast, while responding to a caller named Jacob from Nasarawa State, the defendant even told the people how to build an improvised bomb.
He asked them to go to a filling station to get fuel in a bottle, put a rag in it, that then they should set the rag aflame and hurl it at a soldier. A Molotov cocktail, according to Wikipedia.com, that I accessed at 1 a.m. on 20th November 2025 is a hand-drawn incendiary weapon consisting of a fragile container filled with flammable substances, equipped with a fuse. In use, the fuse attached to the container is lit, and the weapon is thrown, scattering on impact. Unquote. The online Britannica dictionary defines Molotov cocktails as a crude bomb, typically consisting of bottle filled with inflammable liquids and a wick that is ignited before throwing. Unquote. Applying the above definition, the directive of the defendant to members of the group to build improvised bombs such as Molotov cocktail is indeed a terrorist act. A Molotov cocktail is capable of causing explosions, damage like any other bombs, which aim is to cause destruction. This directive, like other directive, is a manifestation of anarchy-minded of the defendant, which is set out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the Radio Biafra platform, carried out so many terrorist attacks, which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I hold without hesitation that he is an international terrorist, flowing from his threat to attack British High Commission and the American Embassy, as well as his incitement against the British High Commissioner to Nigeria at the time, Catherine Lyons, a known woman of peace. In a broadcast of 24th October 2020. The defendant stated thus, and I quote, "Radio Biafra is now in the hands of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown, but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings, and they also bleed. Any person with a police uniform or any army uniform is your enemy." Around 57 minutes mark into that video, the defendant directed his threat at Catherine Lyons, the British High Commissioner. He stated, and I quote, "They came to Tinubu. It is a surprise that after the British Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should not be shocked. The woman is dead, is demon, a big demon. She is too. We go come repentance." Around 1 hour, 8 minutes, 35 second mark, the defendant also stated, and I quote, the same thing that Britain did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bullet-proof door. I don't care how much it costs. We will pay. Everybody who is a welder, who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapons, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed. Unquote. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce same parts of the proceedings of that day hereunto. Defendants, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means
that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without any valid law. It is impossible, my lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957, when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that pioneered that very effort, they all went to jail and were killed. Court, I'm learning this now. Then ask the British to leave. Defendants. Yes, in 1957, Dr. Antonia Nao moved a motion at the House in Lagos, asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abad Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my lord. Absolutely, 100%. They told me. They said, I will come to court to see, to hear your case. When you take your plea, when persecution opens, then their case, when prosecution opens their case, when you start your cross-examination, when they refuse your no case submission, I am telling you what happened a year and a half ago when you file your no case submission and is rejected. You will not go into trial. You will be there during the verdict. You will be there during conviction. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was ascertain it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence today, I can extend time for you because your time has ended today. For the U.S. Embassy, it would have been attacked if not for the closure as a result of the protest. The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 24th day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement could mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed inviolable. That means that even though the land belongs to a host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship. Article 22 of Vienna Convention on Diplomatic Relations, 1961, It provides thus: the premises of missions shall be inviolable. The agents of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings, and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution, unquote. Thus, from the above, it can be said that the defendant incited for people to invade British High Commission and is threat against British High Commissioner Catherine Lyons and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commits other attacks on persons or liberty of an international protected persons. B. Carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C. Threatening to commit any such attack, commit an offense, and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an act consistent with agitation for self-determination. Again, the answer is no. All these acts goes to show that the criminal tendency of the defendant as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution as successfully established can cease against the defendant. Consequently, he is hereby convicted of count 6 of the charge. With respect to count 7 of the charge, the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within jurisdiction of this honorable court, a radio transmitter known as Tram 50 concealed in a container of used household items which he declared as used household items, thereby committing an offense contrary to Section 47 2A of Custom and Excise Management Act Cap C45, Laws of the Federation of Nigeria 2004. The dispute as to which law provides for the offense in count 7 has been conclusively decided by the Supreme Court in case of Federal Republic of Nigeria versus Kanu Supra, where my Lord M.L. Garba, JSC, while reading the lead judgment, said, and I quote, a calm reading of the details of the facts stated as constituting the offense mentioned or named therein would clearly and undoubtedly reveal that it deals with the offense punishable under the provision of Section 47 2A of the Custom, Excise and Management Act, Cap C45, Laws of Federation of Nigeria 2004, which provides as follows: 47.2. If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C-45 or Chapter C-45 in Laws of Federation of Nigeria 2004 is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offence in Count 15, is punished and punishable. The offence in Count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide Count 7 based on Section 47 of the Customs and Excise Management Act. The ingredients of the offence are: the defendant must have imported or caused to be imported goods concealed in a container. 2. The imported